Everyone, good morning. This is Joe Adams here. I'm a U.S. immigration lawyer based in Los Angeles and in New York City. I wanted to have a session this morning to discuss current topics in U.S. immigration. There's a lot of news out there. There's a lot of good information, a lot of bad information. As always, your questions are the most valuable part of these sessions. If you're not able to stay through the whole duration of the session, rest assured, I will send a recording of this session to everyone who registered. A few topics that come to mind already. You know, Obviously, this war in Iran, not something that the U.S. Congress has passed. Remember, only the U.S. Congress gets to declare war. Trump's done it anyway, and whether or not he's calling it a war, it's a war. How is that affecting U.S. immigration? Well, the issue is we don't know yet. It's too new. The U.S. and Iran have had a long-standing feud since around the time I was born in 1979, my entire life. The issue with Iran is Iran immigration to the U.S. has been very difficult in the last few years, in the last 10, 15 years, I would say. Notwithstanding the fact that there are a lot of Iranian Americans who live in the neighborhood I grew up in San Diego County, near my current residence in Los Angeles County. So, so if you have questions related to Iran, let me know in the chat, and I'd be happy to address those questions. I think one of the top line themes of the last 12, 15 months has been the lack of change, however, in the way U.S. immigration law has been applied at least in my practice. There are issues where the administration has discretion in any administration. So, for instance, one of the areas where any administration has discretion is the issue of priority. So, if you are, say, an undocumented person, maybe you entered the United States as a tourist, entered the U.S. through proper channels and never departed, are you a priority for enforcement? Well, under prior administrations, Republicans and Democrats, Obama, George W. Bush, Bill Clinton, you were not a priority for enforcement. You were not a priority for removal or deportation, unless you had committed a crime, unless you were a member of a gang, unless you were part of a terror group, unless you had committed a very serious or violent crime. One of the things that Trump ran on and carried out is that everyone is sort of equal priority. So any U.S. government facility has limited resources. Who is a priority? I think as a matter of policy, the terror groups, the gang members, the people with serious criminal issues, ought they not be the priority for enforcement? Trump says no, everyone's equal. So the person who's undocumented, who is cleaning the hotel rooms or trimming the bushes outside, are as equal a priority for enforcement. That's one area where the administration has discretion. One area where the administration has no discretion is the area of who gets a green card, when, and under what circumstances. So during the presidential campaign of 2024, one thing that Trump said, he said at one time, was he wanted to, quote, staple a green card to the college diploma of any foreign national who graduated with a four-year diploma. Whether or not that's good policy, that's not this discussion. Whether or not that's good policy is beside the point. He doesn't have the authority to do it. The Immigration and Naturalization Act sets a system for who gets green cards, when they get them, under what circumstances. And there's basically four broad categories. There's green cards based on family, green cards based on asylum or humanitarian concerns, green cards based on what we call the diversity lottery, the green card lottery, and green cards based on employment. And there are subcategories within them. There's this per country limit that penalizes higher population countries. So if you're a person from China, if you're a person from India, higher population countries, there are more people ahead of you in line, and there's a percentage limit in each category. That's all a matter of policy. What is not a matter of discretion is Trump cannot invent a new category that says, if you are a college graduate and a foreign national, you get a green card. Moreover, This whole Trump gold card, green card business. That is nonsense. One of the big issues that's come up this year is people want to, quote, get in line. This is a scam. And it's embarrassing that the federal government is running a scam. If you go to the government's website, it looks like you're signing up for a credit card that, at 29% interest that may or may not be affiliated with the bank. It looks like a scam website, but it is not a thing. There is no legislation in front of the US Congress right now to reform the way green cards are issued. Congress can, in their discretion, pass a law that says there are no green cards. We end our permanent residency program. Congress could pass a law that says there are unlimited green cards. Anyone who wants one, just sign up online. My own ancestors who came to this country in the early 1900s, it was kind of like that. You'd sign a paper saying you'd been here for a certain number of years. You'd have a family member or a friend saying that you were a good character. You'd pass a kind of a simple health inspection, and then you were a permanent resident. And then a few years later, you could become a citizen. I did some social media content recently on my great grandfather who had come to the United States from what was then Hungary, what is now the Slovakia, one of those parts of the world that constantly changed hands and the borders moved, and I don't blame him for wanting to leave around the time of World War One. Those documents were simple. We could go back to that system if we wanted to, but it's Congress who makes that decision. Okay. So if you see things about the Trump gold card, I would not encourage you to apply for that. I would not encourage you to pay any money towards anyone. And if there's a lawyer out there who wants to charge you money to, quote, get on the list, that lawyer either doesn't know what they're talking about or they are in on the scam. So what does that leave us with? Well, we are left with the system that we've had since the early 1990s. There was a moment of political compromise between a center-left Democratic member of the House from Connecticut and the center-right U.S. President George H.W. Bush, the father, George H.W. Bush. They reached a compromise. They passed a good, not great immigration reform bill. And that's the last time we had meaningful U.S. immigration reform in my lifetime. And nothing meaningful has happened since then of any great consequence to the benefits adjudication side of things. There were subsequent laws related to enforcement, and then of course after 9/11, the way the agencies were structured, they kind of shuffled the boxes so that we dissolved what was called the Immigration and Naturalization Service, the INS. We shuffled that into two different agencies. ICE, which does enforcement, immigrations and customs enforcement, and then USCIS, U.S. Citizenship and Immigration Services, which does benefits adjudication. My practice mostly deals with benefits adjudication, which is a way of saying visas and green cards, affirmatively applying for visas and green cards. If you're on this call, you probably are on my email list, or maybe you saw something online on Instagram or Reddit. I work with a lot of artists, entertainers, people in film and television, entrepreneurs, people in STEM, so high achievers. And what is the go-to pathway that we follow? There's a visa called an O1 visa, O like ostrich, O1 visa for high achievers. And like any visa, there's an expiration date. So you can apply for an O1 visa. It can last for 3 years, and you can ask for additional 3-year increments as many times as you'd like. There are other visa categories out there. We're in the middle of what's called H-1B season right now. A lot of people who are just getting out of college who work in tech will pursue H-1B visas. There's a lot of strings attached to that. Each visa is its own bundle of rights, responsibilities, different processes, different requirements. But for a lot of high achievers, artists, entertainers, entrepreneurs, they will pursue O1 visas. There's no limit to the number of O1 visas that can be issued per year, unlike the H-1B, which has a cap. There's no limit to the number of years a person can be in the United States on an O1 visa. Unlike H-1B, you can pay the lawyer and you can pay the government filing fee. The H-1B rules do not allow for the beneficiary, the foreign national, to pay for the lawyer or pay for the government filing fee. So you always must involve your U.S. employer, which can be appealing, to employers who don't have to foot the bill and don't have to take the laboring oar in finding a lawyer and preparing an application. That's the default visa that I go to for high achievers. Then, when a person wants to become a permanent resident of the United States, not a citizen yet, there's three stages. You're in the U.S. temporarily as a visitor on a tourist visa, a student visa, a working visa like an O1. If a person wants to become a permanent resident of the United States, there are many different pathways that people can follow to get their green cards. A person who has a green card is a lawful permanent resident of the United States. I realize the terminology is duplicative, confusing, jargony. I try to avoid it, but I think it's important to explain how the terminology works. So if you want to become a lawful permanent resident of the United States and therefore get your green card, there's family-based, humanitarian-based like asylum, the diversity lottery, and then employment-based. Uh, I as a practitioner, focus on family-based and employment-based. I've taken a few asylum cases on pro bono, just because those are good cases. But and then there's nothing for a lawyer to do with respect to the diversity lottery. No one can get you there. It is not a corrupt system. There's no bribery. There's no way to get you a better chance. It is a lottery. It is a pull of the slot machine. So the only advice I can give you is just avoid scamming services online, which will take your money and enter you. It doesn't cost anything to enter the diversity lottery, or maybe if the State Department charges a nominal fee, I don't know. But in terms of employment-based immigration, many of my clients will pursue employment-based preference category 1 or EB1. Sometimes they will pursue EB2 NIW, Employment-Based Preference Category 2. NIW stands for National Interest Waiver. Both EB1 and EB2 are self-petitioned. So it's rare in immigration generally to self-petition. Usually you have a U.S. Family member or a U.S. employer petition or sponsor your status. With EB1 and EB2 NIW, you are your own sponsor. With an EB1, we're showing that you match at least 3 of 10 qualifying criteria, or we show that you've won a major international award, something like a Nobel Prize or a Grammy Award or an Oscar, something of that caliber. That's a small sliver of my clients. Most of my clients are showing that they match at least 3 of the 10 qualifying criteria. And sure enough, O1s and EB1s are kind of two sides of the same coin. With an O1, we're showing that you have a very high level of ability, that you are a person of extraordinary ability. With an EB1, we are showing that you are a person of extraordinary ability. We always have the burden of proof. It's always up to us to prove that you're qualified. It's not up to the government to prove you're not qualified, so it's affirmative. And it is a more likely true than not standard, what we call the preponderance of the evidence, to use the legal jargon. More likely true than not that you meet the criteria, as opposed to, say, a beyond the reasonable doubt standard that you might find in criminal law, where if you're accused of a crime, the prosecutor has to prove beyond a reasonable doubt. There can be no doubt in the jury's mind that you're guilty of the crime. It's a lower standard in immigration, but it's still our burden of proof. So what are the kinds of things that we provide to the government to show that you are qualified for an O1 visa or an EB1 green card? We want to show that you've worked in a leading or critical role for distinguished organizations. We want to show any awards that you've won, press where you've been featured or your projects have been featured, evidence of high salary or other significantly high remuneration in relation to others in the field. If you're a member of any panels or groups or organizations that require outstanding achievement of its members, like a professional society, the Producers Guild of America, for instance, for my clients who are television producers, they don't take just anyone. You have to pass their certification, and then they charge a pretty hefty fee to join the PGA. That kind of level of membership. Judging the work of others, either individually or on a panel. So if you're on a dissertation committee, if you are on a scholarship committee, those are the kinds of things we typically provide to show that. If you're in the performing arts, your commercial success is a factor. If you are in academia, your publication of academic works in professional or major trade publications or other major media. Those are the kinds of factors that we looked at. One of the most ambiguous of the factors, it's the one I always come to last, is evidence of your original contributions of major significance in the field. it's hard to get your arms around that. What have you done that others have imitated? What have you done where others contributed to your success? What have you where have you been the leader in your field, where others have imitated you? Sometimes people will focus on, say, the number of patents they've filed or the number of citations they have. That is not a factor for O1 or EB1 consideration. That might be evidence that you hit one or more of these criteria, but number of patents, number of citations, number of publications, that is not a factor. One trend I've seen recently, and it's upsetting to me, there are these new services, let's call them, where they'll say, for a fee, we will build your profile. We're a profile building service. We'll get your papers published, or we'll get your name out in the press. And then there are these other services which say, feed your data into our proprietary algorithm for a fee, and we'll give you a percentage chance of approval. In my view, these are scams. There's been a long trend in U.S. immigration for what we call notario fraud. There's a history. That word notario means something different in Spanish than it does in English. Becoming a notary in the United States is a few hours on an online course, and then you can verify that someone signed a document, like a deed or a mortgage or something like that. The word notario in Spanish is more like the word lawyer or abogado. But that word, that ambiguity in the word, has led people to think that they're hiring a lawyer when in fact they're just hiring a notary. What has this resulted in? Fly-by-night operations where unlicensed people take money, they don't file what they're supposed to, they file something wrong, they file fraudulent documents, and then they disappear under the cover of darkness. So this issue of notario fraud is well established. Now in 2025, 2026, we're seeing a rise of what I call digital notaries or digital notarios, where people will, for a fee, say, you've got a 98.54% chance of success you're in a given category. That level of mathematical precision is impossible. This is about persuading an immigration officer where we have the burden of proof that you have a very high level of ability under the O1 or EB1 standard. Just like a judge and a jury, just like when you're in court, there is no way to guarantee an outcome. There is no way to predict with scientific sounding accuracy the percentage chance of approval. In court, we learned this in law school, you could have, in a car accident case, you could have 10 people, 10 witnesses say that the light was green at the time of the car accident, and one witness says that the light was red at the time of the car accident. The jury is allowed to believe that one person. Maybe the 10 others were distracted. Maybe the 10 others were confused. Maybe the other 10 were not credible. Maybe they were lying even. That's something for a judge and a jury to decide. It is not mathematically possible to predict a jury's outcome, just like it is not possible to predict an immigration officer's outcome. Let's talk about who are these immigration officers. They have a college education. They can pass a background check to get a secret level clearance, not a top secret level, although some of them have that. A secret level clearance is hard to obtain. I had one many, many years ago when I worked for the federal government. It took me 8 months to get that clearance, and it was very, very involved, very rigorous. A lot of disclosure had to be made. A lot of investigation had to take place. So who are you getting in these officers? People who have college degrees, who can pass the background check. The pay's not great. There's a lot of churn within the immigration service, even under the best administration. And this ain't the best administration, to be quite frank. So a lot of people have left the immigration service, a lot of more senior people, and then they're hiring more junior people. So all of that adds to the unpredictability of outcomes. Now, that all being said, we have a very high approval rate, but a lawyer's approval rate has nothing to do with what's going to happen in your case. If a lawyer says, I've got a 95, 98% approval rate, that means that he or she's taking on good cases and fighting back and preparing good arguments. But that doesn't mean you have a 95% chance of approval if you're going with that lawyer. So I always want that information to be top of mind when people are considering pursuing their immigration outcomes. If you're currently in the US and you're a student, Look for OPT programs that provide for work authorization. Use the work permit, the OPT and the CPT strategically. Aim your career at the things that you can do to improve your chances of success. Ticking off a box, judging the work of others, either individually or on a panel. Joining those societies or organizations, even if there's a cost involved. Um, those are the kinds of topics that I wanted to cover this morning. Um, uh, that's what I wanted to leave you with. There's no substantive change in U.S. immigration law. Ignore the garbage coming out of the White House when it comes to immigration, at least when it comes to uh, benefits adjudication. Realize that there are some scammers out there, these digital notarios and these old-fashioned notarios. And then finally, if the Immigration Service gets it wrong, we always can sue them in federal court. This is something that even in more modest administrations, more moderate administrations like the Biden administration, uh, the Immigration Service gets it wrong. And from time to time, we have to sue them in court. One big victory that my colleague just had in Texas, as some of you might know, in EB1 adjudications, there was this rule called the Kazarian rule from the Obama era, which said that even if you matched three of the 10 criteria, on final merits, on the final review of things, we can determine that that you haven't risen to the top few percent of people who do your job. That was I think a very poor decision on the part of the Obama era administration, Obama era immigration service, following a court decision out of the Ninth Circuit in 2011, hotly litigated. And recently, Brian Green, my colleague out of Littleton, Colorado, won in the Northern District of Texas. And at least as of right now, the judge's opinion in that case, which is called Mukherjee, and I'll put a link to that in the email that will follow. The Mukherjee opinion, written by a senior judge named Judge Battalion, is that Mukherjee holds that the Immigration Service improperly applied the Kazarian decision, meaning that the final merits wasn't good law to begin with. What does that mean in real life? If you were denied on final merits, you'd otherwise met three of the 10 qualifying criteria, maybe you should sue the government and appeal that decision. There's a 6-year statute of limitations, but there's an argument that the misapplication of the law goes back even further than that. So if you're one of those people who were denied an EB1, speak with an immigration lawyer about possibly suing the government under Mukherjee to get that decision revisited. We're still in a bit of a gray area. The government has 60 days to file a notice of appeal, and we're still within that 60-day period. I have no way to know what the government's going to do with respect to the Mukherjee decision. That's something that I will continue to monitor and update as I have it on my email newsletter. Unless there are any other questions, I'm going to let you go. It's a busy time right now. A lot of new people are coming through. There is reason for optimism. There is reason for planning. There's reason to be informed, even if your decision is not to move ahead. I totally understand that. If you have any questions, please feel free to reach out to me over email. We could set up a time to chat further. Again, Joe Adams, U.S. immigration lawyer based in Los Angeles and New York City. I thank you all so much for joining me this morning, and I'll talk to you soon.